Lyana, and I want to talk to you all today about a recent case of a local authority and M and F and A and B 2021 EWFC 10. These were care proceedings. The final hearing took place before Elizabeth Isaacs QC, sitting as a Deputy High Court Judge. A deaf party in care proceedings, lessons to be learned. The subject children were A and B, very young children. A was 2 years at the date of the final hearing and B was 1 year, parents M and F. The children had never been cared for by their parents. They were placed together with local authority foster carers. The local authority final plan was one of adoption of the children together. M had initially sought for the children to be returned to her care, but her position at the final hearing was that she felt unable to care for the children at that immediate time. However, M did not believe that she would never be able to care for the children. M felt her needs had not been properly understood nor supported by the local authority. M is profoundly deaf. The definition of deaf and how a deaf person should be treated in law is dealt with in the judgment at paragraphs 16 to 44, which is contained in my notes. M had been assessed by psychologist Dr. Allen in previous public law care proceedings regarding her older children. She was subsequently represented in those proceedings by the official solicitor. Therefore, an updated assessment was completed by Dr. Allen in these recent proceedings. He opined that M was learning disabled with extremely low cognitive ability and she lacked capacity to conduct care proceedings. However, within these proceedings, specialist psychologist Dr. Sally Austin, whose report is dated the 5th of October 2018, disagreed with the previous assessment of Dr. Allen. She opined that M did not have global learning disability, nor that she lacked capacity to participate in proceedings and therefore did not require to be represented by the OS. Dr. Austin opined that professionals working with M need to be deaf aware. Firstly, they need to be able to notice any communication breakdown with M and make adaptations to ensure communication works. And secondly, they need to be aware that the deaf person may have knowledge gaps, not due to a learning disability, but due to missing information. On the recommendation of Dr. Austin, Dr. Andrew Corns, consulting counselling psychologist, provided a parenting assessment report dated the 23rd of December 2018. He recommended that M required full access to information via a lip speaker and note takers, with constant checks to ensure that M had understood the information provided to her. The local authority in that case accepted that its compliance with those recommendations of the experts was suboptimal. However, the judge wasn't asked to make findings against the local authority, but did outline 12 learning points, and those are detailed at paragraph 142 of the judgment, and they are contained in my notes. So what are the takeaway points from this case? Well, firstly, let's ensure early identification of any disability that a parent or a party may have, and consider what support measures and any reasonable adjustments may be required to assist the person to understand and fairly participate. Ensure all professionals working with the person are aware of the disability and have experience of working with others with the same disability or received relevant training in a timely manner. Consider obtaining expert advice. In short, be proactive, not reactive, and don't ever assume.